How you have to refresh recollection. They have to read it to themselves. They can't testify from that. So while that's happening, I want to bring in trial attorney Gabriel Sepulveda-Sanchez in the studio with us, and former LA County Deputy Public Defender Philip Dubé. Gabriel, thank you so much for being here in person. We're watching this together, and I think pretty bad testimony for the defendant when the daughter's saying, "I told my dad I heard something."
Definitely. I mean, there's a lot of the testimony that came out. There's some evidence of motive. She talked about the victim being the breadwinner of the family, them having fights a lot, the arguing getting worse after they stopped drinking. But then that testimony right now where she said that I told my dad I heard something in the middle of the night, and then the defendant says you didn't hear anything. So it's circumstantial, but there is evidence, there's some motive there. They got some good evidence of motive to what the reason was for killing the victim, and also circumstances showing that just sounds very odd that you're telling your daughter, no, you didn't hear anything, you're just imagining something. So not a good witness for the defendant right now.
I would agree with you, and we haven't heard any testimony suggesting, and the defense doesn't have to put on a case, but we haven't yet heard any testimony suggesting anybody else was home with them that could have been heard. And so I think they've kind of narrowed it down to say she heard something and this defendant was the one there with her.
Definitely, yeah, exactly. I agree. That was definitely a good testimony for the prosecution.
I would agree with you. All right, weigh in. Philip Dubé, great to see you. Thanks again for being on with us. What are your thoughts as you're watching this unfold, especially the primacy, recency part of the witnesses being at the end that are like this one, the daughter?
Well, I don't think it's enough. It would be one thing if she said, I think I saw Tim prowling around a window outside, or I heard him yelling upstairs saying, I'm going to kill that SOB. But if all you do is hear a noise, I mean, that could be a squirrel on the roof, it could be a raccoon, it could be a coyote out back. It means nothing. I mean, it's just, in my opinion, it's just too amorphous to say that it had to be Tim. It's just not enough there. I'm sorry, or Herbert.
Right. I'll be curious to hear what else she testifies to after she's refreshed her recollection by looking at her own grand jury testimony. Let's do this. We are going to take a break. When we come back, we'll have more testimony from the defendant's daughter in the dosed and choked murder trial. Stay tuned. Welcome back to Court TV Live. I'm Ashley Wilcott. Thank you so much for being with us today. Now, let's head back to Florida for the dosed and choked murder trial for Herbert Swilley. Prosecutors say that Swilley drugged and then strangled his husband, Tim Smith, in order to receive a large life insurance payout. The defense, though, says Swilley and Smith had an open marriage and that investigators overlooked other possible suspects. Let's get you back into court now. When we left off, we're going back in with the defendant's daughter, and she had just testified that her father told her to say she was sleeping and that she did not hear anything the night Tim was killed.
Does that refresh your recollection?
Yeah.
Okay. What did your dad say to you when you told him that you heard a noise the night before?
To say that I was sleeping and I hadn't heard anything.
All right. Did he also say that's all you need to remember?
Yes.
Okay. So he said you were sleeping, that's all you need to remember?
Yes.
All right. Were you upset after that happened?
Yes.
Okay. Why?
Just because I was confused.
Because your dad said that to you? You were confused?
Yes.
All right. Now, were you awake when your dad went to the landfill that morning?
No, I don't believe so.
All right. Did you help him load anything on his trailer?
No.
Now, after you woke up and your dad said that to you and you were confused, did you text Layla, who was your best friend at the time, that morning?
Yes.
All right. And why? And did you text Layla throughout that day trying to meet up with her?
Yes.
Okay. And why were you trying to meet up with Layla?
To talk to her.
Okay. What did you want to talk to her about?
Just how I felt about everything.
Okay.
Just like wondering why he was acting that way.
All right. You wanted to talk to her about what was happening with your dad?
Yes.
And did you text her that you wanted to talk to her? Okay.
Yes.
Now, while you were waiting to hang out with Layla, did you do anything with your dad that day?
I believe I went and had lunch with him.
Okay. Was that later on in the afternoon or
I think so,
lunchtime? Okay. Where'd you guys go?
I believe Ivy.
Ivy?
Was it Ivy? Yeah.
All right. Is that downtown in Ocala?
Yes.
Okay. And what did you do after you and your dad went to lunch?
I'm not exactly sure. I think I might have gone over her house at that point
Okay.
or went home.
All right. Do you remember previously saying you both went home and took a nap?
Yes.
Okay. Is that
Yes.
is that what happened?
Yes.
Okay. During the lunch you had with your dad, did you talk about anything that he had said that morning?
No.
Right. And did you actually meet with Layla that day and talk to her about it?
Yes.
Before you went to see Layla, did you go to Laredo's where you used to work?
Yes, I think so.
Okay. Why did you go to Laredo's?
I can't remember the exact reason why I went there. I think it was just because I was waiting for Layla.
All right. Would it refresh your recollection to see what you said at the grand jury back in November of 2024 about why you went to see Allison?
Yes.
And for the record and defense counsel, I'm referring to the grand jury testimony, November 14th of 2023, page 43, lines 17 through 22. Again, just read this to yourself. Lines 17 through 23.
Okay.
Does that refresh your recollection?
Yes.
Okay. Why did you go to Laredo's to see your friend Allison?
To just tell I needed a hug from her because I was upset.
Okay. What were you upset about?
Just how him and Tim had been lately.
Okay. So you went to see Allison to get a hug because you were upset how Tim and your dad had been lately.
Yes.
Okay. And then after that, you went to your friend Layla's house.
Yes.
And did you talk to her about the noise you had heard the night before?
Yes.
Now, did you learn later on that Friday that Tim was actually missing and hadn't gone to work?
Yes.
And how did you find out about that?
I believe my dad told me.
All right. Were you concerned?
Yes.
Okay. And did you go home after you were at Layla's after you found out that Tim was missing?
Yes.
And was your dad there?
Yes, I believe so, yeah.
And sometime that evening, did your dad ask you to drive him to the apartment?
Yes.
Okay. Do you know what time that was?
Not exactly sure.
Okay. Was that later in the evening?
Yes. It was later in the evening.
All right. And do you know why he asked you to drive him to the apartment?
I can't remember why he said.
And did you drive him there?
Yes.
Did you go in your car?
Yes.
And did he say why he needed to go to the apartment?
To pick up his gun.
Pick up whose gun?
His gun.
Your dad's gun?
Yes.
Okay. Had you ever been to the apartment before this time right now?
No.
Okay. So you drove your dad to the apartment, and what happened when you got to the apartment?
I believe he got out and got the gun out of the Jeep.
So where did you pull up?
I pulled up behind the Jeep.
Behind the Jeep. Did you get out of the car?
No.
All right. Did your dad go directly to the Jeep?
Yes, I think so.
Okay. All right. And then what did he do at the Jeep?
I think he grabbed it out of the front seat of the passenger. I can't remember exactly.
Okay. What did the gun look like?
It was black, I believe.
Did he tell you why he needed to get this gun?
He just didn't want to leave it in the Jeep.
All right. Did he lock up the Jeep when he was done?
I think so.
Okay. And then what happened? What did he do?
I believe he got back in the car.
Okay. And then where'd you go?
Went home, I believe.
All right. Did your dad ever tell you where his key was to get into the apartment?
I believe it was like a couple of weeks ago. I was talking about that Tim had it, taken it back or something.
Okay. He said Tim had taken the key.
Breaking news, there's a verdict. The verdict clock has stopped. You can see it, 14 hours, 52 minutes in the case of Florida against the 5 defendants in the murder of Suni Bell trial. We're going to take a break now so that we can get you in there. That's a live shot you're looking at right now. Everyone is starting to gather for the reading of the verdict. We'll take a break, come back, and get you inside.
Saturday nights on ION
is our night.
Let's go! Double headers every Saturday at 7 and 10 p.m. Eastern. The new Saturday Night Out is on ION all season long.
Tonight, on Closing Arguments, another dramatic day of testimony in the pregnant mistress murder trial. We'll break down the biggest moments in this death penalty case.
Closing Arguments with Vinnie Politan, tonight at 8, 7 Central, only on CourtTV.
We have breaking news out of Florida. The jury in the death of Suni Bell murder trial has reached a verdict. 5 men are accused of killing the 4-year-old little girl during a drive-by shooting. But the defense claims there's no way of telling who fired that fatal shot. Now, this is a live picture of the courtroom. You can see defendants' people are starting to gather for the reading of the verdict. We're going to keep an eye on that. We're going to keep that up so you can see what's going on. Of course, as soon as the judge comes into that courtroom to get started, we're going to interrupt what we're saying and get you inside that courtroom. Still with us, Gabriel Sepulveda-Sanchez and Philip Dubé. Let me start with you, Gabriel. Again, this verdict form I just was looking at with you, and I love my producer left it for me walking in here because it's multiple pages front and back. You have multiple counts, multiple defendants, along with enhancements. Did they carry a firearm, possess a firearm, discharge a firearm? This in and of itself can be confusing.
Oh, definitely. I mean, just looking at that as a licensed attorney, California and New York, that was confusing to me. And I think I just asked you some questions as a judge that I was like, does this look confusing to me? Or so that's the thing people have to consider when juries are going back there with these instructions. If it's not clear, they can get confused and read into the law a lot. I'm sure you've seen in your trials that sometimes they just interpret one word in that jury instruction wrong, and even though that wasn't really what the judge told them. So yeah, anytime you go to a jury trial and you're just hoping they get it right back there.
Yeah, absolutely agree with you. Now, I've just learned that there is a large police presence gathering there in the courtroom. You can see a few of them on that screen. Again, that is a live shot of the courtroom as we're waiting for the judge to come in. Wow, that is a large police presence. Look at all of them. You can see them all lined up. Now, again, there are 5 defendants, so there are going to be a lot of people in the courtroom, a lot of security, depending on what the verdict is, that's going to be needed. Philip Dubé, let me turn to you. Please, sir, tell us what you think, especially knowing the jury came back with some questions that were very specific earlier today, very specific about what do we do if there are 11 jurors who think this and the other one says no, they didn't do it on some of the charges, things that indicated possibly hung on different charges. Now we understand there's a verdict.
I'm actually proud of this jury. They took their obligation pretty seriously. They were out for over 14 hours. That is a lengthy period of time, particularly when you have 5 co-defendants, and it sounds and looks as if they took their deliberations quite seriously and gave each co-defendant their individual due consideration in deciding whether or not there was enough evidence as to each defendant. It's normal for juries to have questions, and sometimes there's really no rhyme or reason to what they're asking. And sometimes you can kind of decipher clues from the questions thinking, either you're ahead of the game or you need to tell your client to run for the hills. And I've learned that generally speaking, that you really cannot assess a jury's determination based on the questions. It's actually a rare bird when I was right on in interpreting their question. But it sounds like there is going to be a verdict as to all 5 and that there is no deadlock as to any of them.
That does. It sounds like that to me too, and I'm a little bit surprised. Let me ask each of you, and again, if I interrupt, it's only because court is starting. But Philip, let me start with you. In terms, I had such a good question. I just lost it. It just flew out of my head. I know what it was. Philip, in terms of all 5 being tried together, we know the judge made a decision, heard arguments that they would be tried together, judicial economy, efficiency, etc. If you were representing one of those defendants, would that bother you?
Yes, it would. And the reason why is that old expression, hand for one, hand for all. The jury just might throw their hands up in the air and say, look, if one was in on it, all 5 had to have known. You see 3 or 4 of them putting on masks, 1 or 2 of them getting in a car with that firepower. How could all 5 not know that they were up to no good and that violence was afoot? So I think that's problematic. I would rather have all co-defendants severed each have their own trials separately to ensure 100% sort of accuracy by the jury. Otherwise, you run the risk of them just lumping everyone together, just like the court is doing for efficiency's sake. And I think that the right to due process should be an individualized assessment and not a group one, merely to save time and money.
Yeah, and Gabriel, I want to ask you about that, but also I want you to weigh in on some of the emotional testimony that we heard in this case. Specifically, let's listen together, the mother, as she was recalling the night of the shooting.
Before the vehicle stopped, was Suni sleeping in the back?
Yes, she was asleep.
Were you able to hear when the vehicle stopped or after the vehicle stopped any noises that you recognized?
She just kept saying, "Mommy."
Emotional testimony, Gabriel. Talk about the fact they're all five tried together, but at the heart of this is the death, the shooting of a 4-year-old little girl. Is the jury going to be compassionate to that, to weigh the evidence against the defendants?
Yeah, definitely. I mean, you got angry jurors are scary. They're a scary thing. In a civil trial, angry jurors that's when they punish someone. You hear those big money verdicts. And in this situation, I share the same opinion as far as our co-guest.
And let me interrupt. I'm so sorry. I understand we have audio. They're in the courtroom. We just saw Zavante come in. Let's go in together.
All rise for the jurors.
Please back, you all may be seated. Thank you. All right, ladies and gentlemen, my understanding is that you all have reached a verdict?
Yes, sir.
And you are the foreman, sir?
Yes, sir.
If you could hand that verdict form to one of the deputies. Thank you, sir. Yes. Clerk, if you would publish the verdict form.
State of Florida versus Quandarius Hammond, Zavante Sampson, Jalen Bedward, Andrew Thompson, and James Denson. Verdict form. We, the jury, find as follows as to count one of the indictment as to Quandarius Hammond. The defendant is guilty of the first-degree premeditated murder of Suni Bell, as charged. And did the defendant personally carry, display, use, threaten, or attempt to use a firearm? Yes. Did the defendant actually possess a firearm? Yes. Did the defendant discharge a firearm? Yes. We, the jury, find as follows as to count one of the indictment as to Zavante Sampson. The defendant is guilty of first-degree premeditated murder of Suni Bell as charged. We, the jury, find as follows as to count one of the indictment as to Jalen Bedward. the defendant is guilty of the first-degree premeditated murder of Suni Bell as charged. We, the jury, find as follows as to count 1 of the indictment as to Andrew Thompson. The defendant is guilty of the first-degree premeditated murder of Suni Bell as charged. And did the defendant personally carry, display, use, threaten, or attempt to use a firearm? Yes. Did the defendant actually possess a firearm? Yes. Did the defendant discharge a firearm? Yes. We, the jury, find as follows as to count 1 of the indictment as to James Denson. The defendant is guilty of the first-degree premeditated murder as charged. And did the defendant personally carry, display, use, threaten, or attempt to use a firearm? Yes. Did the defendant actually possess a firearm? Yes. Did the defendant discharge a firearm? Yes. Count 2, we, the jury, find as follows as to count 2 of the indictment as to Quindarius Hammond. The defendant is guilty of the attempted first-degree murder of Mary Harrison as charged. And did the defendant personally carry, display, use, threaten, or attempt to use a firearm? Yes. Did the defendant actually possess a firearm? Yes. Did the defendant discharge a firearm? Yes. We, the jury, find as follows as to count 2 of the indictment as to Zavante Sampson. The defendant is guilty of attempted first-degree murder of Mary Harrison as charged. We, the jury, find as follows as to count 2 of the indictment as to Jalen Bedward. The defendant is guilty of the attempted first-degree murder of Mary Harrison as charged. We, the jury, find as follows as to count 2 of the indictment as to Andrew Thompson. The defendant is guilty of the attempted first-degree murder of Mary Harrison. And did the defendant personally carry, display, use, threaten, or attempt to use a firearm? Yes. Did the defendant actually possess a firearm? Yes. Did the defendant discharge a firearm? Yes. We, the jury, find as follows as to count 2 of the indictment as to James Denson. The defendant is guilty of the attempted first-degree murder of Mary Harrison as charged. And did the defendant personally carry, display, use, threaten, or attempt to use a firearm? Yes. Did the defendant actually possess a firearm? Yes. Did the defendant discharge a firearm? Yes. Count 3, we, the jury, find as follows as to count 3 of the indictment as to Quindarius Hammond. The defendant is guilty of attempted first-degree murder of Willie Brown as charged. And did the defendant personally carry, display, use, threaten, or attempt to use a firearm? Yes. Did the defendant actually possess a firearm? Yes. Did the defendant discharge a firearm? Yes. We, the jury, find as follows as to count 3 of the indictment as to Zavante Sampson. The defendant is guilty of the attempted first-degree premeditated murder of Willie Brown as charged. Count 4, we, the jury, find as follows as to count 4 of the indictment as to Quindarius Hammond. The defendant is guilty of conspiracy to commit first-degree murder as charged. We, the jury, find as follows as to count 4 of the indictment as to Zavante Sampson. The defendant is guilty of conspiracy to commit first-degree murder as charged. We, the jury, find as follows as to count 4 of the indictment as to Jalen Bedward. The defendant is guilty of conspiracy to commit first-degree murder as charged. We, the jury, find as follows as to count 4 of the indictment as to Andrew Thompson. The defendant is guilty of conspiracy to commit first-degree murder as charged. We, the jury, find as follows as to count 4 of the indictment as to James Denson. The defendant is guilty of conspiracy to commit first-degree murder as charged. Count 5. We, the jury, find as follows as to count 5 of the indictment as to Quindarius Hammond. The defendant is guilty of shooting at, within, or into a vehicle as charged. We, the jury, find as follows as to count 5 of the indictment as to Zavante Sampson. The defendant is guilty of shooting at, within, or into a vehicle as charged. We, the jury, find as follows as to count 5 of the indictment as to Jalen Bedward. The defendant is guilty of shooting at, within, or into a vehicle as charged. We, the jury, find as follows as to count 5 of the indictment as to Andrew Thompson. The defendant is guilty of shooting at, within, or into a vehicle as charged. We, the jury, find as follows as to count 5 of the indictment as to James Denson. The defendant is guilty of shooting at, within, or into a vehicle as charged. Count 6. We, the jury, find as follows as to count 6 of the indictment as to Quindarius Hammond. The defendant is guilty of discharge of a firearm from a vehicle as charged. We, the jury, find as follows as to count 6 of the indictment as to Andrew Thompson. The defendant is guilty of discharge of a firearm from a vehicle as charged. We, the jury, find as follows as to count 6 of the indictment as to James Denson. The defendant is guilty of discharge of a firearm from a vehicle as charged. So say we all, dated this 17th day of September 2025, signed for Smith the jury.
Would the attorneys like the jury polled?
Yes, Your Honor. Yes, Your Honor. Yes, Your Honor.
Madam Clerk?
Juror number 1, is this your true and correct verdict?
Yes.
Juror number 2, is this your true and correct verdict? Juror number 3, is this your true and correct verdict?
Yes.
Juror number 4, is this your true and correct verdict? Juror number 5, is this your true and correct verdict? Juror number 6, is this your true and correct verdict?
Yes.
Juror number 7, is this your true and correct verdict?
Yes.
Juror number 8, is this your true and correct verdict? Juror number 9, is this your true and correct verdict?
Yes.
Juror number 10, is this your true and correct verdict? Juror number 11, is this your true and correct verdict?
Polling the jury guilty on all counts, all 5 defendants. We have a lot to talk about. We have to squeeze in our break. When we come back, we'll have more on this. Stay tuned. Court TV, your front row seat to justice.